I'm sorry. So why does the BIA review it de novo?
Because the BIA reviews discretionary decisions de novo, so the de novo standard applies to discretionary.
And why do they set a standard at all?
Pardon?
Why don't they just make it discretionary? They set a standard. They say to the IJs, use this standard to measure the decision by. So it is not saying it's purely discretionary. It's saying we're setting a legal standard.
No, it's not purely discretionary in that the IJ could just decide based on anything that it wants. And
like the Attorney General can.
Pardon?
The Attorney General can.
Well, there's a statutory text, and we freely admit that the interpretation of the statutory text is a question of law, and that you can challenge that statutory text and say the board has misunderstood the meaning of these statutory terms. But of course, that's not the challenge that we have here. Now, that is what the board has done. It has said this is what we think the statutory text means. It means make a decision about whether you think this non-citizen's facts are substantially beyond what you would get in an ordinary case. So the BIA has said make that discretionary judgment, make that predictive and comparative judgment, and that's it. There's no legal element to that conclusion. So it's just a weighing of evidence. It really reminds me of the credibility determination and the way that the court talked about it in Patel recently.
Well, Ms. Sinstak, it strikes me that everything that you just said is pretty much a relitigation of the issue that was raised in Guerrero. That the government came in, basically made the same argument. The government said, there are mixed questions and then there are mixed questions. There are mixed questions that are really super factual. And we accepted that distinction when it came to standards of review in Lake Ridge, but we specifically did not accept it when it came to this question. We said, you know what? We don't really care if it's primarily factual. We don't really care if it involves a lot of judgment calls. We don't really care if you have to really kind of search for the legal standard in the inquiry. As long as there is that legal standard, and as long as all the fact-finding that you do and all the fact-weighing that you do eventually has to satisfy that legal standard, and the question is whether it does, it's a mixed question and it's reviewable. That's how I read that decision. You're just, basically saying you don't like it.
No. To be clear, we accept the holding of Guerrero-Las Barilla, and we are not up here saying that mixed questions are unreviewable. So if we thought that the exceptional and extremely unusual hardship had a legal component, even if it was mixed in with the facts, then it would not be reviewable. But what we are here saying is just because a statute a term is in a statute, that doesn't mean that it establishes a legal standard in the sense that Guerrero-Las Barilla was.
Well, the question in Guerrero was this equitable tolling question, which is primarily a question of whether extraordinary circumstances prevent a litigant from doing what she should have done. It's the exact same thing. Are there extraordinary circumstances here? Well, we're going to, think about facts a real lot. What were those circumstances? And how extraordinary were they when they're compared to other circumstances that make it difficult to do what the legal rules tell you have to do? I don't really see any distinction in the nature of the inquiry here.
I disagree, and I first just want to point out that there was no debate in Guerrero-Las Barilla that the court was dealing with a mixed question. So what constituted a mixed question wasn't before the court. But I'm not here disputing that due diligence is a mixed question, and the reason for that is I think exactly what Justice Alito was speaking about earlier, which is that due diligence is a legal concept. It's a creature of the law.
You can say that, but what it asks what it asks a decision maker to do is say how extraordinary were the circumstances that prevented you from following the rules. And that's exactly the nature of the question here. How extraordinary are the circumstances that were involved in a particular case?
Now, you are correct that there is some overlap and there are some similar things that adjudicators are being asked to do. I have to say what I find a little bit unsatisfying, but is just the facts here, is that distinguishing questions of law from questions of fact and discretion is often a matter of history. So one of the things that the court repeatedly has done is just said, is this the type of analysis that the courts have done? It is a question of law. And we see that in TiVo. We see that in Oracle. Is this the sort of question that has been decided by juries or by fact finders? Then it's not going to be considered a question of law. And I really do think that the common law history of the due diligence inquiry, that this is something that was a judge-made inquiry that was always decided by judges, elaborated by judges.
It sounds very complicated. I mean, Ms. Santos says there are 75 of these, and we're going to do that analysis as to whether each of them is reviewable or not reviewable. We're going to look into the history. We're going to look into the source of law. We're going to look into, who primarily has prerogative over this issue. Seems like Guerrero, when it came down to it, this is what Justice Kavanaugh said, is that it's not worth the candle. Of course, these are going to be reviewed extremely deferentially, but if there's a legal standard at issue, if the conclusion that the court comes to is in the end, do these set of facts, as found, as weighed, satisfy this legal standard, then the better course is just to call it a day and say it's reviewable and not have to go any further.
So I want to make a couple of points here. The first is that you're going to have to perform what you're referring to as a complicated analysis, which I would refer to as simply statutory interpretation and what the court does every time it decides a standard of review. And here's where I'm getting to. You're going to have to perform this analysis under petitioner's framework, because petitioner is saying the standard of review is going to turn on whether this is an exercise of discretion. I think she's saying abuse of discretion review. So it's going to turn on whether it's an exercise of discretion or it's a factual finding or it's a question of law. And what we're saying is, look, that's not the right analysis because the statute says, no, it has to be a question of law for it to be reviewable at all. But if you think that, the government's framework is too complicated, I don't think you're going to avoid it. You're just going to get these questions in the standard of review framework.
On the standard of review, there are lots of different framings you can put on it. There are two main buckets, though, deferential or de novo. And I think what she was saying is it's going to be deferential.
I'm not sure.
And so I don't know that you can frame it a lot of different ways, but basically, as counsel said, I think correctly, the usual analysis when you're doing these, and we've done a lot of these, is has the agency jumped the rails of reasonableness and how it determined whether a given set of facts constituted something extremely unusual.
I think the problem here is that questions of law are reviewed de novo. That's sort of black letter law. And in fact, the Fourth Circuit has reviewed a number of these exceptional and extremely unusual circumstances findings de novo because they've said, well, we know the only...
That's not, that's probably not correct to do it de novo in those circumstances is what counsel acknowledged, and I think correctly. Like Judge Murphy said in the Sixth Circuit opinion, I think was, okay, it's reviewable. What changes? Perhaps not much in terms of bottom line because it's going to be deferential review, right?
We think the problem, again, is that the only thing that Congress made reviewable is a question of law. So
well,
as soon as you're talking...
Can I stop?
Yeah.
No, keep going, actually.
No, my point is that as soon as you're saying, no, we're reviewing something that's not a question of law, so de novo review is obviously not appropriate, I think you're in a little bit of trouble because it seems like, actually, now we're talking about discretion, we're talking about fact-finding.
Well, this is now Groundhog Day from Guerrero because we talked about the history of St. Cyr and how the decision there recognized and the subsequent congressional history recognized that applications of law to fact would be considered questions of law, even though I'm with you as a first principle, I might not have gone down that road that Congress did, but that was, I think, the clear understanding of what questions of law covered, and we said as much in Guerrero, so that kind of ended that discussion, at least as I thought about it.
No, again, what Guerrero said is that when you have a mixed question, so that assumes that there is a legal component, but what you have to be pointing to is what is the legal question, and there isn't a legal question here, and if I could just...
So if it says the brief's due in 45 days except in unusual circumstances, is the except in unusual circumstances does that not have a legal component?
That's a discretionary determination. I think that is something where, you have to interpret the terms.
But don't we hold all the time courts of appeals? The lower court abused its discretion as a matter of law. when it reaches a wrong judgment. Isn't that exactly what we say?
I think that sometimes that is colloquially what the, or less
Colloquially? I mean,
I think what that says
isn't
is
that
that is
exactly?
Pardon me,
If
no,
I might
should
just,
not have said
if I might
colloquially,
just,
I agree.
if I might just finish. Yeah. Okay. You agree.
No, I shouldn't have said colloquially, but I will say that what I should have said, which is correct, is that I think that they use that in order to say this is just a really unreasonable exercise of
Exactly.
discretion.
We say as judges all the time that yes, the district court has ample room of discretion in discovery, in undue hardship, in due diligence, and lots of things, but there are boundaries set by law that they cannot exceed. The guardrails are wide, but they're there. We don't say we disagree with this discretionary decision, and we would have done it differently. We say when they've reached those boundaries, they've erred as a matter of law, right?
Yes, but I want to say you have to articulate what that boundary is. So if petitioner
I just want to make
here-
sure I heard the first part of the answer was yes.
The first part of the answer is yes, because we have conceded. If petitioner says, as the law says, exceptional and unusual circumstances, and exceptional does not mean, for example, unique, and here the agency has said it means unique. That's an error of law. That's a misinterpretation of the statute, and that's a guardrail. You're right. That's a boundary. An agency cannot do something that the statute doesn't permit it to do, and if the statute, if they do, and if a non-citizen says you have transgressed the boundaries that the statute sets, then that's a question of law. It has to be colorable, of
But
course.
wait, like
Seems
transgress
like
the, oh, sorry.
Sorry, no, please.
If transgress the I mean, you're saying you put the boundary in the wrong place by saying unique. But transgress the boundaries is, I think, what Justice Gorsuch is getting at. Imagine the worst case possible. Let's say the non-citizen has one child who has cancer. There's no other relative in the country. They have no support network. He's the sole breadwinner. So let's just posit that that's a heartland case for hardship under the statute. Couldn't the BIA or the IJ abuse its discretion in a way that transgresses the guardrails by saying, no, that's not an exceptional and unusual circumstance?
No, in the sense that we think that when you're asking to reweigh or to redo the
It's not reweigh. It's not reweigh.
Well, so I'm not sure that what you're positing is any different than in Patel, where the non-citizen was saying, look, this is an unreasonable determination of the facts. No reasonable adjudicator could have found
No, and
that
Patel
I
is
wasn't
saying,
credible.
no. And Patel is saying, you're wrong, I was credible. That's different. That was one fact. This is saying, here are guardrails. I'm entitled for my eligibility determination to say that I'm eligible if I can show hardship required by the statute, and I have shown something that by any measure would be extreme and unusual, and you have said, applying that statutory standard to my circumstances, that it's not.
So I think there, if you're making it a legal question, if you're saying the term exceptional and extremely unusual
No. That
circumstances,
correctly didn't misstate the legal standard. Let's say, states the standard correctly, but just says this doesn't count.
Again, I think then you are talking about something like the Patel situation. We're saying no reasonable adjudicator who understood the law or who understood that what credibility meant could have reached this conclusion. And that is exactly what the petitioner in Patel was saying. And the court still said, no, it's a question of fact, and so it's not reviewable. And what we're saying is it's the same for questions of discretion. When the agency is being asked to make a comparative or a predictive judgment, that is something that was put off
Counsel,
limits
if I might interject here, in